Hello, so for today's installment of these little refresher videos, I just wanted to turn your mind to the duty of competence. Now, at some levels, this is one of the trickier duties because it sort of feels like it goes without saying, of course you have to be good at your job. But clearly, as we dig into it, the duty of competence means so much more. So where do you start doing some revision around this duty? Firstly, take a look at Rule 4 in the Australian Solicitor Conduct Rules. I think that's a really good place to start. In a nutshell, that tells us that solicitors need to be, or they need to act in the best interest of their clients. They need to be honest and courteous in all dealings in the course of legal practice. They need to deliver legal services competently, diligently and promptly as reasonably possible. And lastly, they have to avoid any compromise to their integrity and their independence and comply with the rules of law. Feels pretty straightforward, right? But it can come up in a number of tricky ways, and I want you to have thought about some of these before you get started. So in order to really understand what the duty of competence is, we need to unpick some of the language here. So firstly, let's start with competence. What does it mean to be competent? Now, I led with, kind of ironically here, for those people who don't stick around for my videos and recordings, with good at your job. Well, actually, competence is not necessarily good at your job. It means that you have to be competent at your job. And so competence includes more than just being able to have a law degree and to identify a legal issue or to identify the right law. It also goes to your capacity to deal with a matter in terms of both having appropriate knowledge and appropriate skill. Another kind of tricky term in here is the word diligence. And generally the courts have found that being diligent means exercising your competence in a careful way. Now, clearly there's some other things that are pretty straightforward here, so clear and timely advice. So one of the things I think is really important here, particularly in the context of us studying this subject in a technology context, is being able to deliver timely advice. So many of you, when you were thinking about technology assisted review, for example, would have been grappling with the risk that the technology makes an error versus the ability to do a review in a competent way, or talking about the specific part of competence here, in a timely and thorough way. And you would be balancing up the risk of missing something over if technology is doing the review that might not have been missed by a human eye, but also the better ability of technology to identify likely cases across big reams of data than a human who will get bored, frankly, and will miss things. Plus, the costs that are associated with big reviews mean that there is this balancing act between the risk of something being missed and doing something in the most effective and efficient way. Another element of becoming competent could be really relevant here, and something I think is worth you thinking about as a prospective lawyer, as well as from the point of view of the exam. So ask yourself, how do you become competent? Now, clearly the first step here is having the right qualifications. So that requires you to go to an appropriate university, to complete the priestly 11 subjects. This is one of them. And then doing the work experience that you need to do and the practical legal training in order to be admitted to practice. And then you're going to be supervised for a period of time. So newly admitted lawyers, their first practicing certificate comes with a supervised legal practice condition. So as a newly admitted lawyer, that basically means that you can't work for yourself. You are going to need to be supervised by somebody else who is appropriately qualified to do that. And what they need to supervise you on is doing legal work. Remember that old problem? Legal work isn't really clearly defined in any of the legislation. So back in the olden days, people like me, we did articles. Well, in Victoria, you would have done articles anyway. And when you were an article clerk, kind of the joke was you spend most of your time picking up dry cleaning and, maybe going to grab the partner that you worked for a cup of coffee. Those days are thankfully long gone. Now we have a very focused way of ensuring that a graduate lawyer receives the level of supervision that they are deserving of. So during their graduate year, they do their practical, they have to complete their practical legal training requirements, but usually for a period of at least 2 years after that, in many firms anyway, there will be a real focus on ensuring that supervision is undertaken appropriately, that young lawyers, or new lawyers is probably a better description here, get access to a wide range of work, essentially to develop their competence. Why? Well, partly because it's the right and ethical thing to do, and partly because there is a requirement in the rules, Rule 37, which specifically provides that a solicitor who has designated responsibility for any kind of matter must exercise reasonable supervision over solicitors and other employees engaged in the provision of legal services. So there is a specific rule that essentially says if you are the lawyer responsible, whether you're in an independent legal practice or otherwise, you have that responsibility. So there is a real value in investing in supervising young lawyers and ensuring that they are learning properly. So the Act, unfortunately, once again, doesn't define what supervision is. However, if you're thinking about supervision, the board, the Legal Services Board, will consider both the position and the experience of potential supervisors. So an appropriate supervisor needs to have the appropriate experience. So I shouldn't be supervising you in matters relating to court appearances because I do not have suitable litigation experience, but nor should my colleague who spends all of their time in the magistrates court be supervising you in relation to ASX takeovers because they may not have, well, they would not have that kind of experience either. An appropriate supervisor will not be subject to supervised legal practice restrictions themselves, so it is not appropriate for you 1 year out with that condition to be supervising and signing off on somebody else's work. They should provide regular support and feedback sessions, and they should have sufficient authority in respect of the work performed by the supervised practitioner and be able to direct, amend, override or intervene in relation to the legal work performed. So while a supervised legal practice requirement is imposed on practitioners, supervisors need to remember that they themselves are subject to legal and professional obligations to act with due skill and diligence. So it doesn't remove your obligations, the fact that you're being supervised, but it does provide an extra layer of obligation on the person who is supervising you. It's really important too that we make sure that when somebody is being supervised, that they're doing legal work, that the supervision relates to legal work that they're doing. And again, remember that circularity. I think I've mentioned it a couple of times. A key case in this, which you would have found in your reading along the way, it's certainly referred to in Del Pont. It is D'Alessandro and D'Angelo and Bouloudas. So the second time I said and is the V for verses there. So the firm was D'Alessandro and D'Angelo, and Bouloudas was the defendant in this matter. And that case sets out a number of points that then Chief Justice Malcolm listed. This is a New South Wales decision. I think it's a New South Wales decision, WAR. I will come back to that. So the points are, number one, the obligation of a practitioner to supervise an employed clerk is imposed in order to ensure that the client receives an appropriate standard of advice and service. So I think that would apply in relation to graduate lawyers as well, or anybody with the supervised legal practice condition. Failure to adequately supervise the work of a clerk or somebody requiring supervision may constitute unprofessional conduct. The nature and extent of the obligation to supervise will depend upon the particular circumstance in which the solicitor's practice is conducted. The level of supervision required will vary according to the level of competence and experience of the clerk or the person requiring supervision, but must remain supervision and not be a complete delegation. Supervising solicitors should settle and sign all letters. There should be in place a system by which each file relating to a matter to which a clerk or a person requiring supervision has the conduct can be reviewed and by the solicitors at appropriate periodic intervals. Proving witnesses, discovery and inspection of documents must be carried out under the direction of and specifically reviewed by supervising solicitors, and so-called general supervision, which relies on a clerk or a junior lawyer bringing any difficulty to the attention of the solicitor, will not be sufficient. Again, I'm focusing on supervision for no particular reason other than I think that it is a really good inroad into thinking about the ways in which your obligations as a young lawyer are impacted when it comes to the duty of competence. Questions, concerns, frustrations, compliments, don't hesitate to sing out if I can help. Cheers.